Crimes against property, malicious mischief. The crime of malicious mischief can be defined as the damage to or the destruction of someone else's property. The property must be damaged or physically injured. The property itself can be anything and the degree of damage can be very slight. The actus reus requires damage to the property. The mens rea requires deliberate and wicked intention to damage the property of another. A case example is Clark versus Syme, 1957, where the accused was convicted of malicious mischief for shooting his neighbour's sheep. Another example is Ward versus Robertson, where the three accused were charged for walking across grass where sheep were grazing. The damage itself was to the grass. In HM Advocate versus Wilson, the accused activated an emergency stop button at Hunterston B power station and caused an outage, leading to £147,000 in losses. As it was done maliciously and there was a financial cost, this was enough for it to be classified as a crime. Vandalism. Vandalism is a statutory offence contained within Section 52 of the Criminal Law Consolidation Scotland Act 1995. To infer the actus reus, the Criminal Act is the destruction or damage of a property belonging to another, without reasonable excuse. To infer mens rea, the damage or destruction must have been carried out wilfully or recklessly. The Crown must specifically prove, beyond reasonable doubt, the accused acted without reasonable excuse. A case example is in McDougall versus Ho, 1985, where the accused damaged the windscreen of a taxi as he believed wrongly that a person who had just broken his shop window was escaping in it. This constituted a reasonable excuse. In Black versus Allen, 1985, the three accused had been involved in horseplay or rough boisterous play when one jumped onto another and was thrown off the back of the other straight through the window of the Clydesdale Bank in Pennycook. The magistrate who convicted the accused had not considered whether the horseplay created an obvious and material risk of damage to the window, the then test for reckless conduct in Scots law. The High Court held it was impossible to determine whether the accused had acted recklessly, and the convictions were thus quashed. Vandalism with fire raising. Willful fire raising and culpable and reckless fire raising are different in that they require a different mens rea, or intent. The actus reus, or criminal behaviour, is the same for both, which is setting fire to any kind of corporeal property as long as it belongs to another and the accused does not have the owner's permission. Willful fire raising. Willful fire raising is the more serious offence, and its mens rea is the actual intention to damage or destroy property which the accused has ignited. In Byrne versus HM Advocate 2000, on an appeal, the 5-judge court held that in order to convict the accused, the Crown had to establish whether he intended to burn the relevant property. He had set fire to some paper on the floor of a building owned by a housing association in Dundee. Perhaps he only intended to burn the paper, not the building. They couldn't establish the mens rea, the criminal intent, and the conviction for willful fire raising was quashed. There is no scope for transferred intent. If an accused meant to only burn curtains, he is only guilty of willful fire raising of the curtains. It would be culpable and reckless fire raising otherwise. Culpable and reckless fire raising. The mens rea is when a property is set on fire by the accused displaying a reckless disregard as to what the result would be. Recklessness in this context basically means that the accused's actions show a complete disregard for any dangers which might result from what he was doing. And that's from Carr versus HM Advocate 1994 per Lord Justice Hope at 208. This definition of recklessness applies specifically to cases of culpable and reckless fire raising. Fire raising to defraud insurers. This crime consists of setting fire to one's own property. The act must have been carried out with the intention of defrauding an insurance company. it is not necessary that the fraudulent claim is actually made. An example is Bashir versus HM Advocate 2022, where Mr. Bashir set fire to his family business to claim a 1.75 million payout. He was imprisoned for 13 months. That concludes the damage to property section.